Good morning, everyone, and welcome to today's webinar, demonstrating GDPR compliance, technologies and tools to get you there faster. Before we get started, I'd like to go over a few items so you know how to participate in today's event. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions pane of the control panel. You may send in your questions at any time during the presentation. We will collect these and address them during the Q&A session at the end. So we will be recording the webinar today. Please sit back, relax and enjoy the session. I would now like to introduce today's speakers. Mark Darby, founder and chief executive of Alliantist, the organisation behind ISMS.online, and Matt Pritchard, pre-sales consultant at activereach. Just handing over to you now, Mark. Thank you.
Thanks, Lorna, and welcome everybody. Thanks very much for the opportunity to share some thoughts with you about how you can demonstrate GDPR compliance. I just thought I'd very quickly contextualize. Alongside ISMS.online, I run a business that delivers a secure cloud software service called PAM, and we have a whole range of sensitive information sharing solutions that we work with across government. So we, 6 or 7 years ago, had to develop ISO 27001, a whole range of pan-government accreditations, and it was painful. It was remarkably expensive, time-consuming and hard, especially being in a small business. And with things like GDPR coming up, I felt there must be a better way. And so as a result of that, we developed ISMS.online. And when we come to think about GDPR and compliance, I just want to hopefully click through the page. Let's just see if that works. So when we think about GDPR, I've often heard people over the last 12 or 18 months saying, oh, the regulator wouldn't be interested in coming after my organization. And of course, we can debate that a lot, but what is clear, if we're not concerned about the regulator, then we really should be concerned about our powerful customers, our employees, our suppliers, our industry bodies and others who are going to want to hold us to account. And certainly doing nothing now, I think, is just not an option. And we've gone beyond the kind of why are we doing GDPR and almost to some degree, what is it? We're going to touch on some of that, but how and how quickly is probably the most important thing. I don't know if any of you saw today that our government contracted, but Crown Commercial Services sent out today the new sign up that you have got to accept their GDPR compliance clauses. So what should we be demonstrating GDPR compliance against, given that there is no GDPR certificate at this stage? So I want to be able to show you a way that I think you can take this forward. So if we just click against that again. For those of you that have read the regulations, you'll know that they are remarkably difficult to kind of follow and get through without significant help. But the ICO is a great place, certainly as the UK Supervisory Authority, to look at for information. And another great place which can give you a trusted badge is a UCAS independent certificate for the information security parts of what are expected within GDPR. And we're not going to have time to go into all of that sort of stuff on this webinar, but if you look at the power of triangulation, there are some very significant opportunities to demonstrate that you can be trusted with one or more of these areas. And I would certainly start, if you haven't got a great level of maturity around information security and around data protection, then I would certainly start looking at the ICO's approach to GDPR, which I'm just going to again click through if we can get that, click through to the next slide. And so on this particular, let me just see, is that clicking through? For some reason it's not clicking through. Can you click that through for me, Lorna? Thank you. So you'll probably know that in the GDPR regulations themselves, there are about 180 things that you need to consider across the articles and recitals. And we've certainly looked at that. We're working with a number of customers around that in our particular platform. But I wanted to introduce this much more pragmatic approach. And the ICO started with a 12 steps to GDPR, but the bridge between the 12 steps high level through to actually 180 plus things that are within the actual regulation was too big. So they've now brought out these 7 checklists that they've been updating over time, and I would thoroughly recommend them to everybody on this call, no matter how big or small your organization. If you follow that hyperlink at the bottom, you'll get your 7 checklists, and that will give you a great starting point from which to consider the areas that you might need to invest in further. So with that in mind, let me now simplify what those 106 things need to be, that you need to look at in a little bit more depth. If we can click again, Lorna, on that. So I've broken it down into 8 areas where you need to not only implement, but you also need to manage in an ongoing fashion and demonstrate that you can be trusted through your auditing, through your reporting, through your supply chain. And again, we're not going to go into the whole detail of your sub-processes and everything else on this call, but these are the sorts of things that you will want to have solutions in place for, starting with that information that you hold, most importantly, moving through then risk assessing and understanding some of the consequences and impacts around the risks about the information you hold, putting in place the policies and controls, both at the individual's level and at the information security level. Max is going to talk much more about the operational security side that sits behind this. Here we're looking at the ongoing sort of management system side of it. DPIA is really important, SARS really important. They may not be used frequently, but you have got to have solutions in place for them. And then on that right-hand side, really looking at the nature of incidents, how you're managing those and preventing those. And of course, the yin and yang in all of this is your staff and the supply chain. And so you need to think about the solutions around that and bringing it all into some form of whole system assurance for your board, for your stakeholders, for your customers, to demonstrate that you can be trusted. And if we just click through, I'm going to literally give you a very, very high level, some screenshots of how we've addressed those 8 things in our particular platform. So what we've got here is a screenshot of 2 different starting points for ISMS.online. If you are not working with powerful customers and they aren't going to dictate to you or transfer the risk to you for saying you need to have ISO 27001 as an independent certificate, then you could perhaps start with something like the Information Commissioner's Office standalone solution. So we've built all of that checklist, those 7 checklists, into our platform with a whole range of what we call adopt, adapt, and add policies and controls. And I'll show you a couple of things around that in a second. But if you are working with powerful customers, if you are looking to be trusted around more information beyond personal data, then actually it makes an awful lot of sense to start looking at doing ISO 27001. And we've integrated that into our platform. So you can actually start with GDPR and integrate it with your 27 so that you've got to your 27,000 over time by meeting the core components of the GDPR first. So we've got those 2 options. And if we very quickly just scroll through again, Lorna, if you could for me. this particular slide is taking you beyond what the ICO are saying around, here's an Excel checklist that they've recommended. The problem with Excel is it's quite static, not very dynamic. You can't link to it easily. You can't evidence off it and report from it, and so on and so forth. So we've built an inventory and records processing tracker that's very customizable, really easy to work with. And that is going down a storm at the moment with customers doing GDPR. If we quickly move on from that, Lorna, to the next one. So one of the areas around risk assessment and assurance that needs consideration is this confidentiality, integrity, and availability based approach to risk. Well, because we've got an ISO 27001 certified risk solution in our platform, we can make that available for customers, whether they're doing GDPR or both, and a whole range of other regulatory or certificate-based standards. So if we move on from that one, Lorna, I'm just wrapping through these really, really quickly to give you a flavor and some ideas of things. DPIAs, SARS, and incident management, you have got to have solutions in place for these things. We've built all these really easy to use, simple solutions. I'm not going to dwell on them now, but they're in the platform as things that you can demonstrate and evidence that you have in place, even if you're not using them very frequently. If we move on from that, Lorna, to the next one. So I talked about the yin and yang, and for organizations that have got to have confidence that their staff are following policies and controls, we've developed something that we call a compliance policy pack solution that allows you to, in a really simple Kindle-like reading fashion, demonstrate that your staff are able to understand the policies and task for compliance around them and stay updated in a kind of almost continuous compliance fashion, rather than just do it once a year and that sort of thing. You can definitely do it once a year, but we're in a more dynamic world, so you want to be able to more dynamically update things. All of that we've sorted. And then if we very quickly move on to the next one, Lorna. So supply chain, what we've built here inside the supply chain is an optional module around managing your supply chain based on the value at risk. So again, I'm not going to dwell on this too much, but it's all about importance of relationships, relationship management, contact management, demonstrating that you know your DPOs, that you've got in place that flow down of all of those customer delivered things that are required. So you can demonstrate that end-to-end assurance, not just around GDPR, but anything that the customer is looking to flow down or the regulation is looking to flow down. And if we push that down a little bit further, Lorna, onto the next one, I think this might be the last one, not sure, just want to touch on to give people a view here of how you start bringing this together. And I talked about the whole assurance of the system, and no doubt Max is going to cover in a minute the kind of operational side of all this. But what you want as a senior manager, as a stakeholder in a business, is to understand where your risk is, and is the platform, is the service performing in the manner that you expect it to, so that if someone did knock on your door, you're able to evidence all of that in an easy to use one place to work. And we've built that inside our environment, so you've got everything in one place from which to develop and manage your GDPR through to the broader information security. So when we talk about compliance, my view is that you should aim to achieve compliance against what your UK supervisory authority is saying is minimum best practice. We've built that in. What you should then look at is, do you need to be moving further into ISO 27001 as an independent cert? If so, we've built that in to help you towards that. And you can get there much more quickly and visibly, so that you can demonstrate that you're on that journey to compliance by May the 25th. So that's it, just in a nutshell. By all means, come and book a demo if you'd like to learn more, but I'm going to hand over to Max right now. Thanks, Max.
Thank you, Mark. Yeah, we're just handing over now to Max Pritchard, pre-sales consultant at ActiveReach, that's going to run through now the technological aspects of this webinar.
Good morning, everyone. My name is Max. 25 very odd years ago, I found out that I could type messages to people in different countries using a battered old college computer, and they could reply in real time. It blew my mind, and I've been hooked ever since. Somehow I've ended up in a career where much of my time is spent explaining to people why sharing personal information with strangers abroad might not now be as good a thing as what I thought it was back then. And so, GDPR, where are you on your GDPR journey? I'm still having conversations with companies who haven't really started yet. But even in the most well-prepared organisations, they might benefit from me throwing some light on some of the overlooked corners of the GDPR puzzle. By now, I hope that you've nominated someone to be responsible for data protection within your organisation. And if you've been very lucky, it might be you. If you're anything like me, you may have put off looking at GDPR for as long as possible, but now the deadline's in sight, things need to be done so that if it comes to it, your company can demonstrate compliance and avoid regulatory action. And in that, I hope some of the following is going to help you. GDPR is really light on technology, very, very light. In fact, it goes out of its way to avoid specific technologies by name. What it does demand is a modern, cost-effective and proportional system for managing personal data with due regard to the state of the art and privacy by design and by default. In other words, it seems really important to realize that the regulation is technology agnostic. It does not care how you get there, but you do have to be able to prove that you have got there. You need to demonstrate your response to the threats to the data subject, confidentiality, integrity, and availability of their data. But how can you prove that you've done enough? Looking at the deadline of the 25th of May this year, it's very tempting to see the GDPR world something like this. Even the title of this webinar on reflection falls into this idea of sprinting towards a finishing line. We're trying to help customers get there faster, but where is there? How do you know when you've done enough? What it is easy to forget is that outside of the non-technical responses to GDPR, such as nominating someone to be responsible for data protection, minimizing the amount of personal data being collected, reducing the amount of time it's being stored for, and deciding on the lawful bases that you have for capturing, processing, and storing personal data, compliance, like data security itself, is a process and not a destination. You need to be building a business culture of respect for personal data and constant vigilance. A very common model in information security is this security wheel, popularized by the networking giant Cisco. It envisages the state of security as an ongoing marriage, not just a wedding day, a continual process of reinforcement, use, and testing that work together to maintain a state of constant, restless improvement, rather than steady decline and eventual obsolescence. If you have not started yet, I think businesses of all size should focus their short-term technological GDPR improvements on a smaller number of the most common threats to personal data, but implement both security controls and ongoing testing and improvement processes together. So first, I wanted to look at the most common causes of actual real-world data breaches and the technologies used to mitigate those risks and to test that protection. According to security research giant SANS, the top 3 threats by impact in 2017 to the security of data across almost every business that relies on connectivity to the public internet are threats from email, such as phishing, whaling, and business email compromise, or BEC, malware, like ransomware and viruses, and denial of service attacks. Also on the rise at the moment and implicated in the loss of large quantities of personal data from companies are attacks on web and cloud infrastructure. I'll touch on that as well because it's a growing threat, and companies are likely to lean on web communications to enable data subject access to their own data and allow them to object to data processing and otherwise engage with an organization's personal information management system. Email appeals to criminals for a number of reasons. It's ubiquitous, it's cheap to use, and we're so familiar with it in our everyday home and work life that we're lulled into complacency. We are perhaps all familiar with malware arriving as file attachments to emails, and Nigerian princes trying to con us out of money with promises of fabulous wealth. It's very 1990s. Maybe we're less familiar with spear phishing, whaling, and BEC attacks, which are getting really difficult to spot, even for professional paranoids like me. If there's one place in a business to put layers of security and conduct regular testing, it's your email system. You want to have a good endpoint protection solution, antivirus, including for your mobile phones. ActiveReach also supplies anti-malware gateways and cloud-based email security services, giving you defense in depth. That absolutely needs to be combined with regular staff training on cybersecurity and ongoing phishing simulations to help people be aware and stay alert. Test it, keep it current. Malware is a blanket term for viruses, worms, ransomware and the like, malign software that does things to and with your devices that you don't want. Email is one way for malware to get into your business, but it's only one of many. The WannaCry ransomware last year infected hundreds of thousands of computers by exploiting poor internal firewalling, poor patch management, and static defenses. The impact on people, particularly NHS patients, was bad, but could have been much worse without a drop of good fortune. Removing or disabling unused or legacy software from computers, i.e. hardening, implementing internal firewalls or filters, as well as at the office perimeter, can help. For the testing services that you would need to keep this protection fresh, you ought to consider regular host vulnerability scans and occasional expert penetration testing, both from the outside in and from the inside out. Again, regular staff training can really help sharpen your detection of IT issues that may indicate a breach, as well as toughening up the so-called human firewall. And it's an essential part of the cycle of continual improvement you need to prove in response to a GDPR audit or inspection. Third in this hit list of security threats that require technological attention are distributed denial of service attacks, or DDoS. When people think of security, attention naturally moves to threats to confidentiality. GDPR is unequivocal, however, that availability of personal data is a security objective. If we think about the WannaCry ransomware attack again for a moment, this makes complete sense. The impact on people was because NHS staff could not access personal data, bookings for operations and medical appointments. Critical human systems are increasingly going online, and online systems are increasingly prone to being knocked over by anyone with a grudge or just the inclination. DDoS attacks are used by criminals to exhaust computer and network resources of a target, like a water cannon turned on protesters. The amount you prioritize your defenses against DDoS will very much depend on the impact on the data subjects of loss of availability of your public connectivity. DDoS protection is going to be a much higher priority for certain categories of personal data systems, medical information, travel documentation, credit and payment gateways perhaps. There are two main types of protection against DDoS attacks: large-scale flood defenses against big volume attacks, usually consumed as a subscription service from cloud DDoS mitigators, and on-premise DDoS devices to protect certain sites or data centers from more insidious, low-traffic DDoS attacks. Also, not to forget, keep DDoS detection and configuration up to date with regular DDoS testing to turn a static decaying defense into a focus of ongoing improvement. ActiveReach is a specialist in DDoS mitigation and testing, and I'm more than happy to discuss this with people afterwards. DDoS attacks are often seen alongside attacks on web-based infrastructure, designed to access and steal data directly from databases. Does anyone remember the attack on broadband provider TalkTalk? A DDoS attack was used to disguise a web application attack that resulted in tens of thousands of customer records being stolen. The most common form of these attacks on websites are SQL injections and cross-site scripting. They exploit weaknesses in websites that are designed for customers to create an account or to submit information to companies using forms, in other words, personal data. There is a special type of firewall technology which is probably easiest consumed as a service from a cloud provider, which is called Web Application Firewall, or WAF. We offer a selection of cloud WAFs alongside WAF devices to customers. WAFs sit between the users and malicious actors and your website and make sure that the transactions are legitimate. On its own, vital for many interactive web applications, but best combined with regular vulnerability assessments and the occasional penetration test to keep the configuration up to date. So that was a rapid charge through 4 areas of security technology and testing, which are high priorities for cyber attack. I also wanted to take the time to talk about some other areas of activity which in our experience are proving to be places where companies have blind spots or need a bit of tidying up. The first is to do with personal data in perhaps unfamiliar places, and the other is the interaction between a data controller and third parties. The GDPR's definition of personal data is really broad. It's not limited to what US regulators define as personally identifiable information, or PII. It includes information that might indirectly be used to identify someone, including identifiers like IP addresses, recordings of someone's voice, someone's image in a photo or on video, and logs of computer activity. There is a class of personal data capture, storage and processing that is sometimes overlooked when identifying personal data flows in organizations. In this class of flows, I include voice capture technologies like telephone voicemail and call recording, image capture like video conferencing, CCTV, and network and computer monitoring applications. I think it's a good idea to touch on these now, because making sure these flows are on the radar of companies is a good first step to establishing processes of transparency and lawfulness for data subjects, be they customers or employees. Call recording systems and voicemail, as examples of voice capture, are well established and widely deployed in business. The history of voicemail is not as a network service. The digitization of voice and the ability to access voice remotely over networks was a retrofit. In a lot of cases, the security controls on voice systems have not been very good. Voicemail hacking in the UK has an emotional resonance that perhaps other EU countries have not experienced. The News International scandal proved beyond doubt that voice recordings can contain very personal data, and that the levels of protection afforded by telcos and PBX providers are not always good enough. 4-digit PINs are easy to crack, even if they're changed from the defaults. In 10 guesses, I can unlock 15% of iPhones locked with a 4-digit PIN. If you want to chat about compliant PBX, unified communications or call recording, then please contact us after the webinar. CCTV systems share some of the features of voicemail in that they were developed independent of ubiquitous internetworking, and they often lack the sophistication in security controls that one might hope for, perhaps a fire safe to store a VHS tape, for example. However, because CCTV has always been a device used as a security measure, or maybe because it's a heavily regulated application, it's more likely to be included in conversations about the secure flows of personal data used by business. CCTV is covered by many areas of regulation, not just GDPR, potentially the Human Rights Act, the Freedom of Information Act, and the Protection of Freedoms Act. The ICO has published excellent guidance for businesses about the use of CCTV, and I can't improve on their advice here. Just don't forget CCTV when you're looking at GDPR. Finally, of note, are network and application monitoring tools. Modern network vendors and developers are massively in love with web portals, web interfaces, and APIs. Routers, switches, access points, cloud servers, cameras, phone systems, security appliances, and the whole gamut of Internet of Things routinely collect and make available data logs that can be used to track and analyze user location and behavior. With IP addresses and user login information coming under the category of personal data, this proliferation of potential data capture, even if it isn't actively used by a company, is a gold mine or a landmine, depending on how you want to look at it. It can help in efforts to detect breaches, but can also be abused for criminal gain. GDPR is specific in referring to personal information collected to better secure networks. Recital 49 states that the processing of personal data to the extent strictly necessary and proportionate for the purposes of ensuring network and information security constitutes a legitimate interest of the data controller concerned. Legitimate interest, capital L, capital I there. The trick to network monitoring systems is that concept of necessity and proportionality. Given how common event logging is in networked appliances and computers, there's probably a need to actively seek them out and switch those off that you don't need. And additionally, think carefully about what you are doing with the logs, who you share them with, and how long you keep them for. Regardless, you may want to conduct a legitimate interest assessment, or LIA, for each monitoring activity. The very last point I want to cover today is not, strictly speaking, a technical issue. GDPR recognizes the difference between data controllers, organizations that decide what data to collect and process and how, and data processors who are relied on by data controllers to store or process personal data on their behalf. Most organizations have dozens, if not hundreds, of data processors, which may not be obvious until you start unpacking the data flows from data subjects into and through the life cycle of the information within the data controller. In most cases, the contract governing the relationship between the controller and the processor was agreed prior to GDPR being an issue, and many companies have not considered whether the suppliers that they use have provided sufficient guarantees about their security measures. Article 28 of GDPR is specific in demanding a binding contract or other legal act between the controller and every processor. It seems to me to be a vital step to build a list of processes and begin the grind of reviewing the contracts, updating them, getting processors to provide sufficient guarantees, perhaps in response to security questionnaires. In this process, having a tool like ISMS.online to help organize, prompt and collate documentation, such as contracts or processor questionnaire responses, not just for the 25th of May, but ongoing, is really useful. So that's everything I wanted to cover today. 17 minutes really isn't sufficient to do that justice, but I hope it's given you some additional food for thought. If you are responsible for your organization's data protection, then I salute you. You are doing something noble, and you have my sincerest best wishes.
Thank you very much, Max. We're now going to begin answering the questions submitted during today's presentation. As a reminder, you can still submit any questions through the questions pane in your attendee control panel. We will do our best to answer as many questions as we can during today's session. If not, we will follow up with you after the session. Okay, so our first question is a question here for Max regarding privacy impact assessments. So what is a privacy impact assessment and when should it be applied? We are a financial services firm handling sensitive personal data.
A data privacy impact assessment, DPIA, is a way of doing a formal assessment of the risk to the data subject of a particular information flow. So where it's required is in what the regulation calls high-risk activities, like the introduction of new technologies to an existing business, or any kind of large-scale or systematic monitoring or profiling of individuals. So things that might demand a DPIA might be CCTV surveillance, social media profiling, where you're looking to segment customers within particular demographics, or where you're starting some kind of initiative to share data with a new organization. Probably also included in the DPIA would be sort of staff monitoring technologies, where you're looking at tools to manage productivity of staff in an automated manner. I hope that covers the answer to that question.
Yeah, thank you, Max. Another question that's just come in. In your experience, what are other customers using for data mapping and data flows? I think probably Max would be best placed to answer this question.
Sure. There are a number of tools out there to do formal data mapping. Many of them are very expensive, and so they seem to sit at the enterprise level and are gradually moving down the size of organizations, but smaller organizations might struggle to find something that they can just plug in and get an automated report. In our experience, the best source of information for building a map of your information flows and third-party processes is doing stakeholder interviews across the business. So we often go into organizations and spend a day or two with key people in the organization, crossing finance and HR and customer relations and support. And from the people who work in that organization get a very good view of the data applications that they are using on a day-to-day basis, and then combining that with knowledge of their IT infrastructure and network diagrams, and looking at the flows going in and out through firewalls or security appliances, you can build a very decent map, at least a starting point. And of course, using a tool like ISMS.online to keep a track of where you're up to in terms of identifying these flows can keep it current and fresh as the company continues to change over time.
Okay, thank you, Max.
Sorry, Lorna, can I just add to that with what Max has just said, that I think it's also a great opportunity, rather than looking at it just through, say, the kind of GDPR compliance lens. There's a great opportunity here for business improvement, because what we've seen from people starting to do their information mapping is that, as Max has said about the stakeholder interviews, is that you often find that staff have been using other tools. So back to one of Max's earlier slides about, knowing where your data is, that they've been using other tools because the tools they may have been provided actually stifled them to get their job done. So there's a great opportunity to actually do process improvement and system improvement, which can run the business better. So I wouldn't even see it just as that kind of compliance exercise. Max, I think you'd agree, it's a great opportunity for business improvement, cost reduction at the same time.
Yeah, shadow IT is a growing issue with applications appearing on networks because people are like water running around a rock that's placed in their way. And yeah, that often goes against the ideas of the security policy and what we need in order to ensure the protection of end user data.
Yeah.
Yeah, we've got a few people that have asked various questions around penalties. If companies are found to be not compliant with GDPR, what are the penalties, and also does the data subject have a right to compensation? I'll pass that over to Max.
Okay, I'm not legally trained, so apologies for that in the first instance, but there's been a lot of talk around the new fine regime to bear in mind around GDPR. There are really two levels of maximum fine that's available to the regulator in terms of breaches. So for a serious breach of GDPR, the maximum administrative fine is up to 4% of global turnover, or 20 million euro, whichever is higher. For other breaches, such as inadequate record keeping, regulators do have the power to issue penalties of half of that much, so up to 2% of global turnover, or 10 million euros. Now, I think the article in which data subjects can claim compensation is Article 82 of the regulation. There is a right of action for the data subject to claim compensation from a controller or processor. So if data has been incorrectly held or used and the individual has suffered damage, companies could find themselves on the end of legal action as a response of that. Outside of all of the kind of formal legal shenanigans that might result, don't overlook the possible reputational repercussions of non-compliance. We have seen company share prices and product sales dip markedly on the back end of successful cyber attacks and notorious breaches. Information will be in the public domain, and staying compliant is going to be crucial for any business seeking to maintain their reputation, particularly how companies respond to a breach with the ability, the demands to notify the ICO in the UK and possibly the data subjects if their data is breached as soon as the breach is identified.
Sorry, Lorna, if I could just add to that as well, in terms of the reputational consequences, 100% agree. And I think that smart customers, I talked about powerful buyers earlier, they're already now getting ahead of the game here by saying, let's mitigate our risk, let's manage our risk. If they're not already transferring that risk down their existing supply chain through the contracts, they are definitely starting to manage it much more through the tender process, the new procurement approaches that they're taking. So if you can't demonstrate your compliance or your ability to be trusted, then actually your survival is at risk. You know, that's the kind of worst case outcome. But I think if you do it well, then this can be a differentiator and you can demonstrate that you're on that journey, because the ICO have often said, you know, that they're not going to come after people that are showing the right intent to do stuff in that regard, and they're not looking to find people the maximum that are obviously looking at showing the right intent, but something has genuinely gone wrong. So all of those things that Max has talked about and we've talked about will help you drive towards that ability to even get yourself on the tender list in future.
Okay. Thank you, Mark. I think we've got time for just to answer just a couple more questions. As I said, we will get back to everybody else on an individual basis. Do registration pages on a website require an active consent box added so that the individual consents to us holding their data, or is a statement detailing which information we may hold through their registration enough?
I think this strays into areas of legality, but the principle is one of lawfulness. There are 6 different lawful reasons why organizations may collect and process personal data, and consent is only one of them. So if consent is the basis by which you are collecting the personal data, then absolutely on whatever tool you are using to collect that data, the data subject needs to be aware that that is the basis of your collection and how you are managing their data subsequently as you know, a consequence of that legal basis for collection. But there are other reasons to collect data, and it might be, say, the execution of a contract requires you to have certain pieces of information, and you may well use a web tool in order to collect those pieces of information. In that case, you may have to have different messaging for the data subject to make sure to be transparent about what you are collecting, what it is for, and what you're going to do with that information. But it gets into quite a complex area because each of those legal bases has different requirements on the data controller for notifying the data subject and on how they handle access rights to that data from the data subject itself. So if consent is the basis of collection, the data subject is able to remove that or withdraw that consent at any time. And you have to track those consent, that state of consent over a period of time that you hold the data. The same is not true of legitimate interest, but the data subject can object to your processing of that data, and you have to make a process of that objection available and clear to the data subject when you collect it. So there's a big answer to what looks on the face of it a relatively small question, and I think that hopefully that touches on some of those areas.
Okay, that's great, thank you. Just one more quick question regarding ISO 27001. Somebody has asked, also they've been thinking about doing ISO 27001, but I've been put off because I've heard it takes a huge amount of time and money. Is that right? I'll pass it over to you, Mark, if you could answer that one. Thank you.
Thanks, Lorna. And I've definitely got the scars on my back from implementing from a position of ignorance, if you like, around 27001, and we made a whole range of mistakes in the very early days. We did this in 2011, something like that, 2012, and we went out and bought policy packs, we had consultants, we had a range of other things, and actually what became clear is that none of it was really actionable and easily business-led into what we wanted to achieve, and also none of it was technology-driven or paperless, if you like. And so when we started to break all of this down, we realized that actually there are a whole number of components, and when you add it all up, it does take quite a bit of work to do. But the reality is it's been tremendously well worthwhile for us. Our business has grown significantly as a result, but the reality is there is an investment there to start with. And one of the reasons why I set up ISMS.online is so that we could help organizations get there much more quickly at much lower cost with much lower risk, you know, by creating the risk tools, the policy packs, the incident plans, giving, you know, we've even built a virtual coach program that means that you don't actually need to go out and spend tens of thousands of pounds on information security expertise, because we've built it into the platform. So there is no doubt that there's a lot of things to do. There's about 140 things to do for ISO 27001, depending on what level of your risk appetite is and the nature of your business. But the good news is that many of those you're already going to be touching on from a GDPR point of view. So if there's ever a time to consider 27001, it's a really good time now to kind of harmonize the approach around that. And whilst, you know, obviously I'm looking at positioning our own software solution, which gets you there quicker, faster, and all that sort of stuff, the reality is there's still a bit of work to do in order to do it. We've just tried to allow people to stand on the shoulders of those who've been there before and get there an awful lot more quickly. So hopefully, you know, it is as long as a piece of string, but you'll get there much, much more quickly if you've already got a platform that allows you to concentrate on what you're trying to do rather than how you're trying to do it, and with something that gives you up to 77% out of the box that you can adopt, adapt, add. So hopefully that helps answer that question, Lorna.
Okay, yeah, thank you. Thank you, Mark and Max. And thank you, everyone, for attending today's webinar on demonstrating GDPR compliance. If you have any other questions, please contact Max via email. His email address is max.pritchard@activereach.net. And if you'd like to speak to Max regarding GDPR-specific technologies, we can arrange a one-to-one consultation. Also, if you'd like to arrange an online demonstration of the ISMS.online Compliance Portal, please do get in touch with ActiveReach initially on that. So once you leave today's webinar, you will receive a short survey. We would appreciate it if you would complete that and provide your feedback. You will also receive a follow-up email within the next few days with a link to view a recording of today's webinar. as well as a copy of our GDPR guide for IT and security professionals. So on behalf of ActiveReach, ISMS.online and our speakers, thank you for joining us today and have a great rest of your day. Goodbye.